Good morning, Mr. Pretorius. Good morning, everybody.
Chairman. Yes,
Morning, DCJ.
Are you ready?
Yes, we're ready to proceed. However, the minister, the relevant minister, is represented by counsel, Mr. Morani, and he asked for an opportunity to address you.
The minister is represented by Mr. Morani?
Yes.
Oh, okay. By the way, he's virtual. Mr. Morani?
Sorry, no, I've got it.
Mr. Nsabeza?
Mr. Morani is present virtually, indeed, and is able to address you if required later. That is my instruction I've just received. My apologies. The
Okay.
minister is represented by Mr. Nsabeza.
Okay, Mr. Nsabeza? If you are comfortable to address me from where you are, it's fine, but if you want to go to the podium, you can go to the podium.
Can I do it from here?
That's fine, that's fine, that's fine.
Good morning, Mr. Chairman.
Good morning, Mr. Nsabeza.
Mr. Chairman, my name is Nsabeza, and I'm instructed by Malulega Seriti, Makume Matlala Incorporated, and the instructing attorney here is Mr. Nano Matlala of that practice. As we have indicated, we are for the minister. And
That's the Minister of State Security.
Minister of State Security.
Yeah.
I'm sorry to interrupt, Chair, but if social distancing is provided for, perhaps we could ask, or I could ask my learned friend to remove his mask so we can, or I can certainly hear him. I'd be grateful.
I'm just not sure whether, there is enough social distancing between the person behind him and the person in front of him, as well as his instructing attorney.
Well, they've duly scattered, so, Chair, it would help.
Are you comfortable, Mr. Nsabeza? In terms of the mask?
Well, no, I mean,
Yes, okay.
I didn't want not to put it on.
Yeah, no.
When the norm is that it should be put on.
Yeah, no. It's just that sometimes when you are speaking, the transcribers can't hear. Sometimes I can't hear. Sometimes I can hear.
Yes.
Yes, yeah.
No. Thank you, Mr. Chairman. Mr. Chairman, as I said, well, I think I probably placed myself on record. I'm instructed by the firm of Malulega Seriti Makume Matlala Incorporated, and Mr. Nano Matlala, sitting next to me here, is my instructing attorney. We represent the minister. The minister is the minister in charge of state security. And the witness, the acting DG in the Department of State Security, is somebody who is in a ministry in which she has got executive authority. Now, the minister was keen, and is still keen, that in the interest of national security, she should be satisfied that even as she wants to cooperate with the Commission in its work, she does not do so in circumstances where national security will be compromised. She understands that, in terms of the Constitution and relevant legislation, Section 209 establishes, the state security, the intelligence community, and her function is to make sure that nothing happens that compromises that state of affairs. May I hasten to add, Mr. Chair, that the minister is quite conscious of the fact that any power and duty that she may have in order to protect the national interests cannot and should not extend to her protecting the unearthing of criminal activities. If anything, because of the position she holds in the executive, she wants to assist this commission in doing so. Now, as we were consulting yesterday, she advised us that she would need to consider whatever it is that his own Director General, her own Director General is going to be testifying about. And what she told us yesterday was that she was none the wiser. In fact, we could have consulted on the basis of what, the consultative process had resulted in, and whatever else there would be that would give us an indication as to what the testimony is going to be about. But as of yesterday, that was not available to us. She phoned me at about 8 o'clock, 7:30, thereabouts, and she advised me that she has just been served with an affidavit. Even though it was our intention to work as we always do throughout the night, so that by now, as she told us that that was the view of the commission, by now we have papers for a substantive application where we will be making a prayer of one for the adjournment of these proceedings pending the filing of those papers which would address whatever it is in the affidavit of Mr. Loyiso.
Mr. Jafta.
Mr. Jafta. You will kill me, Mother, because we know each other for a long period of time.
Yeah, no, I see you.
Yes.
You remember the first name, then the surname.
Yes,
Better than the surname.
Yeah. I suppose it is because I usually address her by her clan name, Ukaba. Without being facetious about things. The minister's concern, and I say so very guardedly and advisedly, arises from what it would be that the testimony would be about. And that was so up to when we left chambers yesterday, and then she sent me an affidavit from Mr. Jafta, which I've read. She still, when I phoned her this morning, she still was keen that we should consult because there are issues that she wants to join issue with in that affidavit. As I stand here, I'm not aware where in that affidavit there are issues that she would like to raise. That's the first thing. The second thing, I'm not aware to what extent they have relevance to what this commission is all about. And therefore, that's why I am in a position where it's a chicken and an egg. If we don't get the adjournment that we need in order for us to put before the commission on affidavit what it is that she would like to join issue with in the affidavit of Mr. Jafta. I am disabled to address your chairman as sufficiently as I would otherwise. That's the one end of the equation. The other, of course, is that we appreciate, and I appreciate, and I think my client does appreciate, that the life of the commission is not forever. And we are looking at what remedies would be available to her if there was no adjournment. If the commission in its wisdom were to decide, well, go and prepare your papers. Whilst you are doing your papers, we are going to be proceeding. And then she would say, oh, what's the point then? Because my fears have not been accommodated. I would have loved a situation where before Mr. Jafta testifies, I am in a position to have put in writing, under oath, before the commission, the essence of what it is that I feel would not be in the best interest of national security if you went ahead and testified. That is
Yeah.
in a nutshell the
Yeah.
question.
I'm going to hear what Mr. Pretoria has to say and what Mr. Mwerane might have to say on behalf of Mr. Jafta. But as you say, you make this request for an adjournment from a very disadvantaged position, because all you are able to say is that the minister says she has certain concerns that relate to national security, but you don't have any details. She received the affidavit around 8 o'clock last night. One would have thought that that was enough time for her to read it and to be able to say to you, at least here are the concerns. They relate to the following paragraphs in Mr. Jafta's affidavit, and these are the concerns which would put you in a very good position, at least, and me to assess whether any claim that what Mr. Jafta may be saying in his affidavit might compromise national security, whether there is a proper basis. I've read Mr. Jafta's affidavit, and I'm not the Minister of State Security. From my own point of view, I didn't pick up anything that struck me as something that could possibly adversely affect state security, no national security. But as I say, I'm not Minister of State Security. She may be in a better position to understand certain things and so on. So, but let me hear maybe what Mr. Mwerane has to say before I hear what Mr. Pretorius has to say, and then we take it from there. Thank you. Thank you.
Mr. Chairman, please.
Yeah, I mention again, you said you are alive, and I'm sure the minister is alive to the fact that as things present stand, the Commission has serious time constraints. It's got to finish its work by end of March. That's not a date we are choosing. It's an order of court. It's an order of court. If we are to get more time, we've got to go to court to get an extension. We are about to launch an application to do that. But the time that we will get is not intended to be time for the leading of oral evidence, but for the preparation of the report. All oral evidence must be finalized, not later than March. And everybody knows that last week we lost a whole week. So every hour counts with us. So there are those serious constraints. And again, from my side, I appreciate, and I think Mr. Pretorius also appreciates, that when it comes to matters relating to intelligence, there is a certain level of sensitivity, and there are certain matters that may need to be protected. But at the same time, I think from what you have said, the minister and I, and that would be the stand of Mr. Pretorius as well, looks like we are on the same page, that to the extent that there may be corruption and criminality within the state security agency, within the intelligence community, that must be exposed. So it's a question of where do you strike the balance and identifying the legitimate issues relating to intelligence that need to be protected while being able to expose corruption. That I think from what you have said, it looks like we are all on the same page on that. It's a question of how do we identify those things that need to be protected legitimately and leave corruption to be exposed without any hindrance. Yeah. Okay. Mr. Moerane.
Morning, Chair.
Yes, good morning, Mr. Moerane. I hope you have been hearing us.
Yes, Chairperson. I've been hearing what's been going on.
Yes, I just want to
confirm that I appear on for the witness, Mr. Jafta, together with my learned colleague, Mr. Ndebele.
Yes.
I just have two things to say with regard to the application. And the first one is that Mr. Jafta is not aware how, and he does not believe that his giving evidence today may in any way endanger or compromise national security.
Yes.
And the second thing that I'm instructed to say on his behalf is that he is keen to discharge his responsibility to the Commission by giving evidence today.
Yes.
Those are our submissions.
Yes. Okay. Thank you. Mr. Pretorius.
Chair, this morning, my learned friend, Mr. Nsebeza, and I had a discussion, as is the ethical practice between council. Such discussions remain off the record. But as we stand here, I think it's necessary to have clarity as to why the postponement is sought and what application is contemplated in due course, because that application may, it is now apparent, have no prospects of success, in which case the application for postponement would not have much merit. I just place that on record to say that if the intention of the minister is to bring an application that it is apparent now to you, Chair, has minimal or no prospects of success, then there is no merit in what may be termed the interim exigency of a postponement to facilitate that. The second point I want to make, Chair, is that the Commission has a mandate. It's a statutory mandate, and it must follow that mandate. Statutorily, it is obliged to lead evidence in accordance with the terms of reference of the Commission, and in open. That's not a desired imperative or an exercise of a discretion by yourself, Chair. It's a constitutional and it's a statutory imperative arising from the Commission's Act. If there is or should be an application to avoid or do it in a different way, that application may, of course, be brought in due course. The question is whether now a postponement is warranted to achieve that position. Great care has been taken by the Director General in consultation with the Commission to ensure that the interests, the legitimate, and I stress, the legitimate interests of state security will be protected in the evidence to come. There is no question of method, legitimate method, or the identity of operatives being released. Any reference to anything that happens beyond the borders of the country has been redacted. Of course, we might have gone too far in that respect, because if a foreign country and this country collude in an unlawful act, we are judged by the standards of our own constitution, not theirs. But in any event, that question doesn't arise. You will have noticed that any reference to a foreign country has been totally redacted in all the documentation. So that could never be a cause for complaint. It may be, Chair, that the real concern of the Minister, and I stress it may be, is less about the criminality line, as you've made very clear, and as I understand my learned friend's position to be, the Minister in no way wishes to prevent evidence of criminality, corruption, or the like, or abuse of constitutional principles not being presented in the open before you. There's another concern. If that concern is the sensitivity of the information, that is for the DG to decide. The DG has statutory powers. He has statutory powers to declassify information and to release information, and does that in the exercise of a statutory duty. The evidence now, I can say so from here, and the evidence that Mr. Jafta will give will clearly be that he has considered very carefully the concerns that may be raised about the legality of what he says, and is satisfied, having considered the position and having redacted quite a great deal of evidence, that the evidence before you is not only proper, but it's his duty to give to you in his evidence. I must say, and this I haven't informed my learned friend about, because I've only got instructions now from Mr. Jafta, that 2 Sundays ago, he spoke to the Minister telephonically, advised her, and asked for an appointment, saying he would give evidence. And that meeting only occurred yesterday. But that meeting has taken place. 2 weeks' notice was indeed given to the Minister. The 3-3 position I will deal with separately. So in short, we have a mandate to present evidence. The Commission has a mandate to deal with the evidence. The law says, and the Constitution says, it must be done in open. That position can only be disturbed on proper application. There is no evidence before you that that position can be disturbed by in-camera application or the like. Clearly, if that must be brought in due course, so be it. But then the duties of the Commission to conclude its evidence must be weighed up against the prospects that will occur, or the outcome that will occur if there's a delay. If there is a postponement now for papers to be filed, we will lose the week. We simply cannot afford to lose the week. And that is not a matter of your preference, Chair. It's a matter of statutory and court import. We are obliged to finish our evidence within a limited amount of time. We cannot afford to lose the week. Those are our submissions.
Mr. Nsebeza? I just want to give you a chance to respond to what both Mr. Moerane and Mr. Pretorius have said in their addresses to me, but I just want to say, it seems to me that having received the affidavit around 8 o'clock last evening, the minister has had enough time not only to read the affidavit, but to be able to instruct you to say, here are my problems or areas of concerns in Mr. Jafta's affidavit. That after 10 this morning, she hasn't given you those instructions to say, here are my concerns in Mr. Jafta's affidavit that, in my view, compromise or may compromise national security. Doesn't count in her favor. But you might want to address that. Yes. Oh, your mic, just switch on your mic, yeah.
We are a team of 3 counsel.
Yes.
And we are ably assisted and instructed by the attorney.
Yes.
Now, my 2 juniors are not here precisely because they are working on the papers.
Yes.
We're rushing against the time that
Yes.
was indicated by the court.
Yes.
In the interim, there are certain I wouldn't call them instructions,
Yeah.
but
Some remarks.
some remarks
Yeah.
where the minister, for instance, says the acting DG raised in his affidavit section 12 of the Intelligence Services Act as being problematic, in that he says it creates an opportunity.
Just raise your voice. Just raise your voice.
If I may, she says, you see Mr. Jafta raised in his affidavit Section 12 of the Intelligence Services Act as being problematic, in that he says it creates an opportunity for the minister through this right to enter the operational terrain, to recruit, to handle agents, to recruit members to the agency, and to instruct members of the agency to fund operations conducted by the minister and persons in the ministry acting in his or her behalf. My probe is that it is probably based on practice where this section has either been abused or misrepresented or misinterpreted. And then she says,
Your voice is going down.
oh yeah. Then she says, this section should not be read in isolation of the PFMA.
Maybe I should stop you there.
Yes.
It seems, at least from what you have read from her remarks that she has sent to you, it seems that at least what you have read so far is not necessarily something that compromises national security. She wishes to put her side of understanding, her own understanding of maybe certain matters that Mr. Jafta deals with, including what a certain section means or what the correct interpretation is. So that's different from national security as I see it. She will be given an opportunity to file an affidavit or give evidence about any matters that Mr. Jafta raises that she may be entitled to respond to. That's separate.
I hear you, Mr. Chair. The problem there is that which is why the nature of this application is one of indulgence, because it can go one of two ways. As the chair indicated, you can get an application. For instance, I did say if Thursday is a bridge too far, we would be prepared to let the papers be filed and served tomorrow. And I don't think we would lose a week. By Friday, we would be able to argue, all of us.
By then, we would have lost a whole week.
It is not as worse as it could have been if we had said we are only going to serve on Thursday.
I can tell you, once we have lost this week, it's difficult for me to think where we would fit in this evidence again within the lifespan of the commission between now and end of March. I've already scheduled a number of witnesses up to about mid-March. There is a long list of outstanding witnesses, and I don't know where to fit them in. I was telling Mr. Pretorius yesterday that we might have to intensify having day and evening sessions. Actually, I think I've asked somebody to look at the COVID regulations and see whether we can there is any exception that would allow us to sit beyond 9 o'clock, or whether we should ask the President to amend the regulations to allow the Commission to sit beyond 9 o'clock to try and fit in all these witnesses and implicated persons that we must hear. So you would have seen already last year, second half of the year, many times I would be sitting during the day, and when we finish at 4 or 5 o'clock, another team comes and I sit until 7, 8, 9. So we are under tremendous pressure. So if we lose this week, I don't know where I could fit in this very important evidence. But I come back to the question. It seems to me that the minister has had enough time from 8 last evening to read the affidavit of Mr. Jafta and be able to instruct you to say, these are the areas in his affidavit that, in my view, compromise national security. And I can't see why she would not have been able to do that up to now. And
except that my juniors are working on.
Yes, well, and of course, I would have imagined that if she said to you last evening, I would like you to ask for an adjournment. Obviously, the first question is, what are the grounds for asking for an adjournment? If she says this evidence will compromise national security, okay, we'll need to have that to hear what's the problem. And if she didn't tell you last night, one would have expected you had to tell you quite early this morning, so that by the time you stand here, you are able to say, it's not in the papers yet because the papers are being prepared, but I know what is going to be in the papers. And what is going to be in the papers is that the following paragraphs in Mr. Jafta's affidavit, in the view of the minister, compromise national security. That's the basis for a postponement. As far as you are aware, you are not aware of that part. Maybe your juniors, whatever they are working on the papers, are already aware, but you are the one who should have been informed because you were the one who was going to move the application.
Mr. Chair, can I seek an indulgence? Or can we have a stand down? Because
Yeah.
I would like to take some instructions.
For 10 minutes only.
Yeah,
Is that right?
10 to 15 minutes.
Mr. Pretorius?
No objection.
Yeah, I'm going to stand the matter down for, let's say, up to 20 past. Up to 20 past 10 on my watch, it's 8 minutes past. Yeah, and then we will resume. We adjourn.
Yeah.
Yes, Mr. Nsabeso. Yes. Yes. I'm sorry. Yeah, okay.
Yeah, I'll get used to it. Yeah, Mr. Chairman, when we adjourned, we were indicating to the chair why it is critically important for us to be granted the indulgence that we are asking for. Because already, I will address later on the question of why didn't we deal with it last night?
Yeah. Yeah.
But there are critically important points that we would like to raise, and that is in relation to just the factual basis. We believe, as is commanded by the Act, that there should have been a consultative process between the minister and the DG. In fact, in terms of Section 10(O), the DG is enjoined
Just complete to say of what act?
of the Intelligence Services Act 65 of 2002.
Chair, may I
Yes.
interrupt for the sake of the record? I'm informed that the transcriber is having difficulty in picking up my learned friend's voice. So either he should come to the podium,
Yes, I think
or
that's
should
good.
stand much closer to the microphone
Yeah, maybe you should.
and speak a little louder if I may urge him to do so.
Your choice, Mr. Nsabeso.
I always want to be nearer to the seat of power.
If because of the.
Perhaps he should come to the podium. Do you mind?
No, I don't.
It seems much more comfortable where it is. It's your choice whether you go to the
Well,
podium
I'm next to my attorney who is going to be able to.
or to be scribbling. Yeah.
Scribbling.
Well, maybe you can be there. Just raise your voice, and the transcribers will tell us if they still can't hear you.
This is not a loudspeaker. Am I audible now?
Yes, they say that's fine.
It is a loudspeaker.
Oh, yeah, okay, all right, yes.
Okay, all right.
Now, the plea we are making, Mr. Chair, for an indulgence to be able to commit on paper what the basis is that the minister is uncomfortable about in the matter proceeding today to hear the evidence of the DG is because already from just what has been said between us, there is a dispute of fact. Which therefore calls upon the parties to ventilate those issues in the manner that had been suggested. Come on paper, let us have the benefit, full benefit of what you are saying. For instance, on this whole question of whether or not there was a consultation. In the brief period that you gave us, indulging us with an adjournment, Mr. Chair, we have established that there was, that's our version, there was no consultation 14 days ago.
And how does that compromise national security? the absence of consultation?
The consultation is a process that is required in terms of the legislation. Because some of the issues...
What does the section read? Let me just hear. I don't... I'm sure there's a file that has got all the legislation that we have. Registrar, or maybe you can just...
I do. God have mercy upon us. I do. God have mercy upon us.
Section 4 of that Act, Mr. Chairman.
It's 10 subsection 4.
Subsection 4.
And which
Subsection A.
Yeah. The Director General must, as far as reasonably practicable, take steps to ensure that national security intelligence collection methods, sources of information, and the identity of members of the agency
Are protected from
unauthorized disclosure.
Yes.
That says nothing about consultation.
And then bracket C.
Well,
I want to read all of the sections I want to rely upon.
Read one at a time and tell me how it advances the minister's case.
The point made here is that the DG, who is enjoined by that section to ensure all of those things.
Well, the paragraph A says the DG must ensure that the certain national security intelligence collection methods, sources of information, and the identity of members of the agency are protected from unauthorized disclosure. Who has the power to authorize disclosure? Is it not the DG?
Well, I don't understand.
I'm saying who has the power to authorize disclosure? So what it prohibits is unauthorized disclosure.
Yes.
So there must be somebody who has the power to authorize disclosure.
Yes.
And authorized disclosure is not prohibited.
No, it is not. But
Yes.
the point I'm making is that the DG, being the executive officer in the Ministry of Intelligence, owes a duty to the minister to disclose, to have a consultation with her as to whether she can be comfortable that those, imperatives.
Well, that may be between the minister and the DG, but it looks like you have moved from relying on saying that Mr. Jafta's evidence, or the minister has moved from saying Mr. Jafta's evidence may or will, I'm not sure which one, compromise national security, to now saying there is consultation which didn't take place, which is just a procedural thing. And obviously, it may be that during the consultation she would be told information that she could think might compromise security, but obviously that's separate from the process. At this stage, you are talking process, as I understand it.
Yes.
Yes. So I'm suggesting that might be between the two of them, but not the commission.
Yes, but the commission can also not proceed when it is clear that some of the misgivings that the minister does have.
Where is the provision in section 10.4 that talks about the consultation between the minister and the DG?
No, there isn't.
I don't see it.
There is no injunction there that there must be a consultation.
Yeah.
But if you read that, together with section 12.1 of that act, where the minister may do or cause to be done, all things which are necessary for the efficient superintendence, control, and functions of the intelligence services. If you read that and you read it with this section, then the submission is being made that when the DG comes to testify in a commission, in open commission, about matters in relation to which the minister, let alone the minister having to consult with the president, is unaware of, then, as I say, I don't want to make the argument on my feet.
Yes.
I need to motivate it by way of,
Okay, I'm going to try and get us to the end of this argument. As things present stand, firstly, you said the minister had a concern that Mr. Jafta's evidence, I don't know whether she was saying will or may compromise national security. Nothing that you have said so far appears to me to support that. I have read Mr. Jafta's affidavit. I didn't see anything that I think could be said to threaten national security. Either Mr. Pretorius or Mr. Morane has said Mr. Jafta is satisfied that there's nothing in his affidavit that threatens national security. And the minister hasn't said anything through you that seems to support that. The argument then moved to, in terms of the act, there was a consultation that was supposed to take place between the DG and the minister, and I was referred to section 10. In section 10.4, there is no reference to any consultation that should take place between the minister and the DG before she comes and testifies. Even if there was, I would be inclined to think that's a matter between them. And you have now referred to section 12(1). It says the minister may, subject to this act, do or cause to be done all things which are necessary for the efficient superintendence, control, and functioning of the agency. Nothing there says anything to me that supports any notion that Mr. Jafta's evidence may threaten national security. I would like to give you the next 5 minutes to address to me any other argument that you may have wished to address. I'll give you 10 minutes if you complain that 5 minutes is too little, so that I can make a ruling. But so far, nothing that has been said seems to support the minister's concern about national security.
As the chair pleases. Mr. Chairman, I'll only make this point with respect to consultation, and that is a factual inquiry. The minister wants to record that to the extent that there is a submission that there was a consultation between her and the DG 14 days ago. That is disputed.
I think I don't know if I didn't understand Mr. Morane to say there was a consultation 14 days ago. I understood that Mr. Jafta had called the minister. Understood the point that was being made as if the purpose of the call was to arrange a meeting with the minister. That was my understanding.
That's correct, Chair.
Yes. Okay.
As far as that goes, Mr. Chair, the minister, in the application we would hope to make, which has been a subject matter of our discussions here, would like to inform you that he did write letters to the DG precisely because she wanted to be apprised of what it was that he was coming to testify about, so that she can see to what degree it, whilst it does not become obstructive to the work of the Commission, nonetheless takes into account the her misgivings, such as they may be. Now, from what you would read, if you granted us the intelligence, you would be told that in a letter there is a date. The minister wrote to the DG, to which he has not responded. And with your permission, Mr. Chair, the letter, which may be discovered.
Does the letter say anything about supporting the concern that Mr. Jafta's evidence may threaten national security or compromise it?
Those are exactly what she had wanted to have this consultation with Mr. Jafta. If I may,
but she wanted to find out. She has had an opportunity since 8 p.m. last night to read the affidavit of Mr. Jafta and form a view whether there is anything in that affidavit that she thinks may compromise national security. With the time that you have had, I take it that she has not been able to say to you, here are paragraphs in Mr. Jafta's affidavit that, in my view, threaten national security, because if she had told you that, surely that would have been the first thing you told me. So I suspect that she has not told you that.
for purposes of testifying here. In relevant part, for instance, she says, I reiterate the request in my letter dated 20 August. As a matter of urgency, I request you to provide me with the following, and this has not been responded to.
But my concern, Mr. Nsebeza, is
I'm getting there, my lord. I'm
that may
getting
have
there.
been fine before she got the affidavit. She got the affidavit yesterday, last night. She has not been able to say, here are my concerns in this affidavit. It's this paragraph and that paragraph.
But one of the concerns is what I'm proposing to read to you, Mr. Chairman.
Okay.
And that is, she wanted to find out from the DG. For instance, I would like to get from you a list of all current and former members that have been implicated by the Commission. I would like to get a list of all current and former members that have been requested to appear before the Commission, their date of appearance, affidavit submitted to the Commission, and or subpoenas. Documentation from the Commission pertinent to each case. I request the above with the interest of endeavoring to safeguard national security and interest. My request is further empowered by Section 12(1) of the Intelligence Services Act 65 of 2002 as amended, which states that the minister may, subject to this act, do or cause to be done all things which are necessary for the efficient superintendence, control, and functioning of the agency. Now,
Yes. I hear what it says.
this chairmanship may well take the attitude that, you know, you have not said anything to me that says national security is going to be compromised in this way. But she says to her own DG, let me have this, let me consult, let me be sure
But
that I will discharge my own responsibilities,
Yes,
obligations, and functions in terms of the Constitution, if you allow me to do so. And you can allow me to do so if you let me have.
Are those your submissions?
Well, there's just the mundane submission that we want to make, that even when she got the affidavit, which was last night, it was an unsigned affidavit. And I don't know to what extent that prejudices him, because the affidavit was unsigned. And now, His Lordship has asked a pertinent question about what did she do between 8 o'clock yesterday and this morning. She was going to be the opponent, but there was no way we would have wanted to test. And I say this, make this submission without being,
Chair, once again, my learned friend
his
needs
voice
to
has
speak
dropped.
into the microphone.
I make the submission without being facetious.
Yeah.
There is a curfew that is currently in operation. And by 9 o'clock, we're rushing. In fact, I left my chambers at 8:20. And it is not because she was lying on her hands. That is why I keep on reading to you WhatsApp messages. But WhatsApp messages can never substitute for a proper consultation.
Yeah.
So that we may even answer those questions which his chairmanship has asked. And it is in that process where we say to her, but the law says this, the law says, and we may end up saying that there is only one narrow way. There is such one narrow approach. We discuss all the other approaches, and this is our basis for seeking to get the indulgence to make sure that your concerns have been addressed by the testimony or by the... We are not saying Mr. Jafta must not testify, not by a long shot. We are even prepared, as we said, to file our papers by no later than tomorrow.
Are those your submissions?
Those are my submissions.
Yes. Well, you know, it's precisely because I'm very alive to the sensitivity of national security and matters relating to national intelligence and so on that I have really allowed as much time as I have to hear what the minister has to say, what her concerns have. Once you said to me, her concerns relate to national security, immediately I said, well, I must hear, because the Commission certainly would not like to do anything that could compromise national security. But obviously there's got to be a factual basis. It seems to me that there has been enough time from the time that she got the Mr. Jafta's affidavit last evening up to this morning for her to have been able to say, my concern that Mr. Jafta's evidence may threaten national security is based on the following, which is in her affidavit. 1, 2, 3. Here are the paragraphs that I'm concerned about. That has not been done. And you have made reference to certain other points, including Section 10.4 and 12.1. I don't think that they assist in any way. So as things stand, I'm going to dismiss the application. I am not preventing you if later on you have substantive papers that show the or rectify or remedy the deficiencies that that are there now, to bring that application, and I would look at it at this stage, at that stage. But as things stand, and on what you have told me in your address, there is nothing that would justify the adjournment of the proceedings and the hearing of Mr. Jafta's evidence. So the application is dismissed.
As the chairman pleases.
Thank you. Mr. Pretorius?
Chair, I hear you, and I don't want to reopen the argument, but I do think it's important to put certain sections of the Act on record in support of the ruling you have made, and this issue of consultation, because it may affect future conduct.
Yes.
Section 12.1, on which my learned friend and the Minister appear to rely, is very clear. It says that the Minister may, subject to this Act, cause or do or cause to be done all things necessary for the efficient superintendence, control and functioning of the agency. But she is subject to the provisions of the Act. Section 10.4, which is important, Chair, places the power to take steps to ensure that issues named by my learned friend and listed in the section are protected from unauthorized disclosure rest solely in the hands of the Director General, and I stress solely. And then section 27, which is also important, says that the disclosure of classified information or material by former members, and there will be former members who will testify, is entirely a matter in the charge of the Director General. So any powers afforded to the Minister under section 12 are subject to the direct and exclusive powers of the Director General in those sections. There is a provision for consultation when directives and regulations too are issued by the Minister. And the Minister's own regulations, perhaps not this Minister, but a Minister's own regulations make it quite clear, Chair, and this is very important for the proceedings, that a document that continues to meet classification requirements must continue to be protected from unauthorized disclosure. A document must be declassified if it no longer complies with the standards for classification. But most importantly, Chair, classification may not be used in instances to conceal violations of law, that's criminality, inefficiency, or administrative errors. B, prevent embarrassment to a person and/or organization. Prevent or delay the release of information that does not require protection in the safety or interests of the Republic of South Africa. Any other information that does not fall within and the prescribed category. So the powers of the Director General are unqualified in regard to evidence and releasing evidence, firstly.
Yeah.
And secondly, the scope for classification is in fact very narrow. Unfortunately, those are secret regulations.
Yeah. Okay, we have lost 2 hours, but it was necessary that I hear what counsel for the Minister had to say. So, but now let's proceed. The registrar must administer the oath of affirmation.
Chairperson. Chairperson.
Oh, yes.
Chairperson, thank you.
Yes.
Chairperson, earlier on at your chamber, when I availed myself, I had certain issues that I wanted to raise with Chairperson.
Yes.
And I feel that those issues, if they are not raised, it won't be at the best interest of my client.
Yeah.
And probably some of my learned colleagues.
Yes.
Chairperson, I think it is very much important that we do ground check. And I'm glad my learned colleague started in terms of this proceeding to make his submissions. Even though our issue is not closely related to the issue of my learned colleague, but for somehow they've got characteristics.
Yes. Do you want to just remind me who is your client? Obviously, I don't want you to disclose the identity if you are supposed to use a pseudonym.
Chairperson, yesterday, Chairperson, while we were placing ourselves on record, we had housekeeping to do in terms of that. But that was done, Chairperson.
Okay, all right.
And for the purpose of record, in fact, I must say I'm Advocate Vumbi. I'm on brief from PG Matseka. I'm not alone, I'm with my attorney of record, Palasa Matseka. Chairperson, we have agreed with Advocate Pretorius in terms of the name to be used going forward with our client. And for the purpose of record, that name will be Dorothy.
Dorothy.
Correct.
Okay.
Yes. Chairperson, if I may proceed. Chairperson, I said they are good.
Miss Dorothy or just Dorothy?
Miss Dorothy.
Miss Dorothy,
Yes.
okay, all right.
Chairperson, as I was saying, it's of a paramount importance that we do not ignore the rules of this commission. And at the time wherein the rules are changing, the commission must see it of importance that all legal teams are being informed. And we are in solidarity together, and we are trying to assist the commission as best way possible. Chairperson, if this commission is saying it is constrained with time, the commission must involve each and every legal representative that is available to represent their implicated parties in this commission. By so doing, this will minimize the situation of these 2 hours that has been lost this morning.
Do you want
And
to
why-
start? Do you want to start by telling me what the issue is, and then you can
Now,
elaborate?
the issue is, yesterday, Chairperson introduced the witness, which is the ADG, Acting Director General. Now, that came as a surprise for many of us. I don't know if there were others in secret who were aware of that situation. But we then went to write a letter. As soon as we get to our offices, we come together and we share our minds. We wrote a letter, which till now, the Secretary of the Commission, in that letter with attention to Chairperson, has not responded to us. And I don't know if Chairperson is also informed of the letter that we've written.
What is the issue? What is the letter about? Tell me.
The letter is about, should the acting DG today be coming here and testifying or giving evidence which implicates not just my client, but any other person, without having proper notice in terms of Rule 3.3 served on us. Therefore, we believe that it will be of prejudice to our clients.
But as things stand, you are not saying you have a client who is implicated by the DG's affidavit, and your client has not been given a 3.3 notice. So the
Correct.
issue hasn't arisen. The legal team is aware of the rules of the commission, and they always ensure that Rule 3.3 notices are issued, or where they are not issued, and there are reasons, those are stated. So unless you say your client is implicated in Mr. Jafta's affidavit, but he or she did not receive, or she didn't receive 3.3 notice, you don't have, unless you say that you don't have a complaint.
No, I do agree with Chairperson on what Chairperson is saying. But be that as it may be, we stand here not informed of what the affidavit is about.
Yes, but if you are not implicated, you are not going to be informed.
But Chairperson, if
If he is not going to implicate you, why should you be informed?
Chairperson, having looked at the situation that happened yesterday, and my learned colleague is going to also address Chairperson on this issue. The same thing yesterday was made clear.
Now, let's talk about this one. What right do you have to be given a 3.3 notice if your client is not implicated?
The DG sits at the highest structure in terms of administration of the SSA.
What does that have to do with why you should be given notice?
My client, Chairperson, is
Thinks she will be implicated.
We have that, Chairperson. It sounds. I know, and we're trying to work with Chair. It sounds like we are maybe not being reasonable. But if we don't raise this issue,
Okay,
tomorrow,
no,
Chairperson,
this particular point has no merit. Is there another concern?
Chairperson, I thought we must just stand up and make that and place that on record.
Okay, all right. You
So
have
in
placed
case
it on record.
in future we need to raise it.
Yeah, okay, all right. You have placed it on record.
Thank you, Chairperson.
Mr. Pretorius, proceed.
Chair, Dorothy.
Oh, I'm sorry. Somebody else wants to say something. I think, I'm sorry, I think you are too close to me. for social distancing. I think try and be somewhere else. No, Mr. Nsebenza was fine.
Yeah, thanks. Chair, I was saying I'll be failing my clients and in fact the commission itself if I don't put this on record. It is common cause that our clients were not
Remind me again, you have a number of clients, is that
We
right?
have a number of clients.
Okay.
That's correct. None of them were provided with a copy of the DG, or rather a Rule 33 notice or the copy of the DG's.
But are they implicated?
It would be easy, Chairperson, for us to say they were not provided because they're not implicated. But then,
So they think they will be implicated.
but then yesterday, Chair, when we learned that the DG would be testifying, we asked the evidence leaders whether, in fact, why we were not provided with any Rule 33 and whether any of our clients have been implicated. They could not deny or confirm, not deny saying, leaving us to our own devices.
But
This is
unless
not
you,
Chairperson.
unless you say to me, the witness affidavit reveals that your client is implicated, but your client was not given a Rule 33 notice. I don't think that any concern relating to being given his notice really has any merit.
Chairperson,
Unless I misunderstand what you want to say.
clearly, we have already indicated that you do not have that statement.
Yes, but
And-
you're not
and
entitled
for that
to
matter,
it.
Chairperson,
You're not entitled to it until you are an
that is
implicated
correct.
person.
But we have asked the commission, we have asked the evidence leaders whether any of our clients would be implicated. And the kind of, we do not get any response. And
Yeah.
if anything,
Yeah.
we are treated with contempt.
No, being treated with contempt, if it is true, would not be acceptable. But until you hear evidence that implicates your client, you shouldn't worry about anything.
But Chairperson, with regards to at least one of my clients, this kind of conduct is not unprecedented. We have a client who's been implicated by at least 3 witnesses. And during, before those witnesses were called, we were never given any notice. So the Chairperson must understand that.
Are you talking about some time back
Well,
or about
it is
this week?
Well, it is not this week, but it is evidence relating to state security agency.
Yeah.
So there is that commonality.
Look, let's say the legal team knows the rules of the commission. They do the best they can to comply. I accept that sometimes they don't comply. But I think that if they know who your clients are, even if I don't know how you handle the issue of pseudonyms when you talk to them, but if they know who your clients are, they will be able to tell you whether they are implicated or they are mentioned. And normally they would you'd get a Rule 33 notice. If you haven't, I think if you are going to sit around, you'll wait until you hear whether Mr. Jafta implicates your client.
You see, Chair, we can't, we have no reason to accept, and with respect, the legal team's bona fides. And this is informed by, at the very least, what happened yesterday. We were told that, for instance, the statement or the report by Dr. Mufamadi would be, as soon as it is placed on record, would be provided you with copy thereof or access thereto. It has never happened. If anything, Chairperson, the evidence leaders are treating us as spectators. The impression that we get is that if this was court, they would prefer us to sit in the gallery. We are not treated as legal practitioners in the same manner as they are. So we have no reason to accept their bona fides. If anything, they've shown themselves to be mana fide. So we wonder, given the experience that we've had, that three witnesses that implicated my clients, our client did not get any notice. And we were promised, subsequent to that testimony of one of those witnesses, that would be given a copy of that witness affidavit. That was in August. We are still waiting for the same affidavit today. So we cannot accept their bona fides. So it is quite clear that there is a concerted effort on the part of the evidence leaders to deny us what is due to us. So unless if we can get a guarantee that our clients today are not going to be implicated, then there's no point for us being here today.
Yes. Okay, just were those your points?
Those were.
Because then I can, Okay, Mr. Pretorius, do you want to say anything?
Chair, before Mr. Pretorius may be given an opportunity to reply.
Sorry, Chair, can I have an opportunity to answer one by one rather than an army of...
Yes, because it's going to be better. Mr. Pretorius is going to respond to this one first. And then if you are going to, when you rise, you are going to say it's the same, you wanted to add something, let's deal with it at that stage. Let's just deal with this one.
Chair, I take you from you. However, as my learned colleagues have already almost submitted, to an extent, our applications and reasons are almost the same.
Okay.
By the fact that they are different on the basis that we hold different instructions. I cannot take further the argument raised by my learned colleagues of being treated otherwise and also having mala fide. But mine is also predicated on a different argument, maybe taking cue and a plea from my colleague to then address it. Let me stand down for now and then I'll advocate my point.
Okay, all right, thank you. If that mic can be switched off, Mr. Pretorius?
In relation to the first, quote, application, unquote, I didn't understand it to be an application, but merely a complaint. Dorothy is not implicated by the evidence of Mr. Jafta, and that's the end of that story. My learned friend was told, and I quote, in answer to a query, if your client was to be implicated, your client would have received notice, precisely in terms that you've outlined, Chair. That deals with the first application. Second application, I'm not going to accept the invitation to litigate through insult and invective. I think it's unbecoming of colleagues to do that. I will stick to the facts. None of the clients of my learned friend who addressed you second are implicated by the evidence of Mr. Jafta. If I'm in bad faith and I'm not being honest before you, that will be clear, and my learned friend is free to take whatever steps he may wish to do. But it is offensive of that to be made before the facts are known, that accusation to be made before the facts are known. So both applications are without merit. As to historical complaints, if those are raised with us in writing in a proper forum, I will raise them with the Secretariat and will answer.
The issue of the high-level panel report, he raised the issue that they were promised that as soon as
he was given it. According to my instructions, he was given it at the beginning of evidence. Well, certainly one person was.
Yes, but he can get it, or the link.
Yes, it'll be available on the link. I don't know, Chair, what technological issues arise about uploading evidence. It's not an easy matter, but it will in due course, or has been. uploaded on the website.
Yes.
That is the end of our remit, is to, in fact, ensure that the instruction is given to do so. The execution of that is not within our hands.
Yeah. Well, obviously, it doesn't assist him if he is told the legal team gave instructions. Whether those instructions are carried out, the legal team doesn't know.
Well, my instructions...
Because his complaint is the commission is not giving me, so we need to, somebody needs
Chair,
to
if I may
sure.
just intervene, the affidavit is on the website. The report is on the website, was uploaded last night.
Of the commission,
Yes.
website of the commission.
Yes.
Okay, then you should be able to get it as soon as you can. Yes. Okay, all right. It's been cleared that your clients are not implicated. Ms. Dorothy is not implicated. I think counsel at the end there still wanted to say something. Let's hear.
Thank you, Chair. And to an extent, I think maybe I'm answered, but
You
I
are
don't want
covered.
to live in that pool of confusion because we stand here for different clients.
Yes. But if you are covered, I'm happy because we are losing some time.
Yes.
But
Chair,
obviously, if there is
I'm-
still something that you need to address, you must address if it's important.
Yes, mine might not even be an application, but a clarification from the Chair. And this comes from almost to the same reasons what my learned colleagues have advanced. And I hear the predicament that Mr. Pretorius might have because he's most of the day standing here arguing points, but supported by a particular structure. I want to place it on record, Chair, that he hasn't so far, and I've not heard him probably because I was stopped to say whether or not my client is implicated. And I'm also guided by the chairman's wisdom to say, if you did not receive a notice, therefore it can be presumed that you are not implicated. But I don't take comfort because on the past experiences and to an extent the chair has also considered to the fact that some witnesses, an error to the team has been able to tender evidence without such notice being given to us. And that is not also unfounded of what has transpired yesterday. For instance, I've carried the chair before yesterday to a notice that was given to us on 3 projects. It was almost 3 pages. That was not significant. But when Dr. Mufumadi gave testimony, he gave a lengthy, which is obvious, from affidavits, it might be expatiated by oral evidence. To an extent, Mr. Mufumadi then said, and to the evidence leaders' comments and propositions that were put to the witness, to the extent it was implied that my client, in particular whom I'm representing, the minister, at that particular time, had at least transgressed his powers, had at least done something that has not been founded. Certain allegations of misconduct, to an extent of corruption, has been, and to the conclusion of the evidence of Dr. Mufumadi, it was agreed that this will be expatiated by the evidence of the DG. That is what then we got to know that the DG is coming tomorrow. So I will not then sit here and think that without even an undertaking. And then immediately when I left here, I wrote a letter to the contact person that I've been provided yesterday. Until today, what I was responded to was that we have taken the whole correspondence to the team who will revert. That leaves me and my client hanging. To an extent that we cannot even make any election of whether or not do we sit here and become observers, as my learned colleague called it, spectators.
Yes.
Not only that, Chair, if I may finish this point.
Yeah.
I'm sure, and we are all privy and alive to the fact that the Commission has a lifespan that is short. But we are almost the accounting authority to the Parliament joint committees, and implications were made that during that time we were almost asleep and we didn't execute those functions. And that's the proposition that, and at least the narrative that has been persuaded. There's no way from where I'm sitting at that the DG, to an extent, if I listen to my senior addressing this, to the extent that the affidavit was of the witness was quoted to an extent of including the powers and separation of powers, which became an issue yesterday. So there's no way that I can therefore assume that my client will not by implication, be dragged into answering. Not only that, Chair, finishing the point, the other point that Chair has instructed us, and I stood on this point yesterday, to say we were directed to consult with the team and to an extent give you what will be the way forward. Nothing fruitful with respect I can say of that consultation came out. We came before the Commission yesterday not being sure. We have correspondence that we have given after receiving the 3 notices. We were ignored, literally ignored. So we came in having not been able to know whether do we elect to participate or bring an application. And Chair, when my learned colleague made submissions, suggested that if there's a need for you to make any substantive application, we'll hear it. And that's how we somehow concluded the morning. We still are not sure today, and I'm seeking your indulgence on this one because it might be an ancillary point, that we need to hear from you, Chair. By implication, yesterday I was heavily implicated, my client that is. So I seek your indulgence within the time frames that the Commission has to know, because we indeed received the notice. We at least to a minimum knew what was going to be, but we thought because of the engagement, we'll know what steps will be taken. But until now, we have not had any responses. Therefore, leaves us with no alternative but to file an application, one, to cross-examine the witness that happened this. So I seek your directive on that point.
Well, I think what should happen is while Mr. Pretorius leads the evidence of Mr. Jafta, members of his team should meet with you and with whoever else among the lawyers wishes to find anything from Mr. Pretorius' team. Let there be discussions outside the venue. Ask whatever questions you want to ask. They should do the best they can to answer them. Maybe at the end of that discussion, you will be satisfied with the answers. Maybe you might not be, but I'm sure it will achieve something. I think while Mr. Pretorius leads Mr. Jafta, that is what should happen. Mr. Pretorius, what do you think?
Well, that can happen, Chair. Engagements have taken place. Correspondence has been sent.
Yeah.
Correspondence has been answered.
Yes.
My concern is that the rules are clear.
Yeah.
My learned friend's client received a 3-3 notice or 3-3 notices and has capacity and rights in terms of the rules to answer. It's not for us to give legal advice in relation to what a party should or shouldn't do. The rules are clear. If my learned friend wishes to file an application under 3-4 to cross-examine or to put up a version, he must do so. It's not our job to interfere in that.
We will continue with Mr. Jafta's evidence, but one or more members of Mr. Pretorius' team should have a discussion with you and whoever other lawyer among the lawyers who may want to ask some questions or whatever, or let them talk.
We'll put that in motion, Chair.
Yes.
Okay. Thank you for that directive, Chair.
Okay, all right, thank you. Okay. At long last, let's get going with Mr. Jafta's evidence. He has been sitting there for a long time waiting. Yes, Mr. Pretorius.
Has he been sworn? May Mr. Jafta be sworn?
Oh, by the way, yes. Please administer the oath of affirmation.
Please state your full names for the record.
Loyiso Jafta.
Do you have any objections to taking the prescribed oath?
No, none.
Do you consider the oath to be binding on your conscience?
Yes.
Do you solemnly swear that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you. You may proceed, Mr. Pretorius.
Sonak. Thank you, Chair.
Thank you.
Mr. Jafta, you have before you an affidavit. The cover page is marked Exhibit YY3. Do you see that?
Yes,
The
I
cover
do.
page you've just looked
Yeah.
at. If you go through to page 52 of Exhibit YY3,
Well, Mr. Pretorius, you want to first announce that we will be using SA bundle SA or SSA bundle 02 most
yes,
of the
Chair,
time.
same one as yesterday.
Yes, same as yesterday. Yes, you can then proceed.
Right, so bundle SSA 02. If we go to Exhibit YY3, page 52, is that your signature there, Mr. Jafta?
Yes, it is.
Your affidavit then, which begins at page 35, is that the affidavit that you have submitted to the Commission?
Yes, it is.
And are you satisfied that the contents are, insofar as you're aware, true and correct?
Absolutely, they are.
Right. It does have certain annexures which go through to page 29. We will probably not refer to them in any detail, but Chair, may Exhibit YY3 be admitted on the record?
The affidavit of Mr. Loyiso Jafta, which starts at page 35, will, together with its annexures, be admitted as Exhibit YY3.
Mr. Jafta, you are the Acting Director General and Accounting Officer of the State Security Agency. Is that correct?
That's correct.
In preparing this affidavit and in interactions with the Commission, you have had the benefit of legal advice from senior and junior counsel and an attorney.
Yes, that's correct.
In paragraph 4, you make some comments about the considerations that informed you in the preparation of this affidavit. Would you place that on record, please? You can read it if you wish, but in your own words would be preferable. Paragraph 4.
Can I read it?
Yeah,
Yes,
you can
please
read
do.
it. Yeah.
I limit this affidavit in terms of its content to narrow issues at this stage, as I'm conscious of the need to respect matters of national security. The Director General of the agency is compelled in terms of Section 10, subsection Section 4, 10.4 of the Intelligence Services Act 2002, Act 65 of 2002, to, as far as reasonably practicable, take steps to ensure that national security intelligence, intelligence collection methods, sources of information, and the identity of members of the agency are protected from unauthorized disclosure. Consequently, all information contained herein and matters that I deal with at this stage and the identities of the person involved are those that are already in the public domain. That's paragraph 4.
Yes, Mr. Pretorius.
When did you become Director General or Acting Director General of the SSA?
On the 17th of April, 2018.
Did you
Do
then...
you remain acting DG or are you already DG?
I remain acting, but in essence, the responsibilities are not for acting. So,
No, I accept
yes,
that when you are acting,
yes,
you have the same powers as
yes,
the full DG. I was just checking whether
yes, I'm still acting,
you
Chair.
are
Thank
still acting. Yeah, okay.
you.
Yes, you say you became the Acting Director General on the 17th of April 2018.
That's correct.
You would then have familiarized yourself, I presume, with your powers under the Intelligence Services Act, and you would have called for information concerning the activities of the State Security Agency.
That's correct.
What did you discover? Or what did you become aware of?
It's a bit of a process, so I'm going to take a bit of time, but not too long a period of time. One of the things I became aware of immediately after assuming the responsibilities of being Director General of the State Security Agency was that systems for proper management, particularly of the finances and their expenditure, were not adhered to. One of the things I believe in is that any organization, one of the indicators for determining the health of an organization is to follow the money. It is, to a degree, what blood is to a human being. Money doesn't lie. So one of the things that immediately became apparent was that there was quite a number of officials of the State Security Agency who were registered in the, if you will, in the register of debtors. In other words, members who owe the organization money. And these were fairly large amounts of money, often running into millions of rand. And I could not but seek to understand how it could be that members would owe a state organization so much money. It then became apparent in the explanations given to me that in fact the systems for corporate governance, both in respect to the management of financial resources and the prosecution of operations, was done parallel to the prescripts that were there. And that obviously led to me discovering that, as a matter of fact, the monies were being expended often, or in some cases, on projects that were outside the boundaries of our legal mandate. There were also commitments that we had, obligations that we had to several parties. And then when you want to understand, but why do we have this obligation to this person, you then realize that, as a matter of fact, even the Constitution might have been disregarded in the pursuit of those operations. I will go into it with a bit more detail. But, Chair, what became very clear was that the Constitution and the law of the Republic, as it applies to the State Security Agency and other entities of the state, was, I don't know how to put this politely, but it was elective adherence, sticking to the prescripts of the law. This was elective. When the law or the Constitution barred one from doing certain things, creative ways were conjured up to go around the Constitution, to go around the law, and do things that were unlawful, were outside the Constitution. I don't want to belabor the point. I do presume that Dr. Mufamadi spoke to it yesterday. The very foundation of the State Security Agency, from the amalgamation of the National Intelligence Agency, the South African Secret Service, and the other entities in that environment, was established in terms of a proclamation and not in terms of what the Constitution required. And then from that, it's not a theoretical exposition, it's factual. A lot of other infractions followed. So I don't know, I could go on and on. But suffice for me to add just a few other points, Mr. Pretorius and Chair. There are other weaknesses that are systemic, and perhaps my view is that these are not just within the SSA, they are there in government, state-owned enterprises, and maybe even in the private sector. And one of those is compliance assurance institutions and processes. These typically are subordinated to the accounting officer, and they become only robust after the fact, or rather they become robust only after things have happened. So there isn't a system yet where we have compliance assurance instruments that run parallel with the conceptualization, the development, and the approval of projects. You see, an accounting officer with the people below him are biased towards achieving the goals. They are biased towards carrying out the activities. And completely without any malafidus, they might overlook certain requirements because of this bias to do certain things. But if you had a compliance assurance instrument that is not subordinated and sufficiently autonomous of the accounting officer, that would help. It's quite another matter where such instruments must report to. That is another thing I picked up, that there was a systemic gap in the management of the intelligence environment, the civilian one. And naturally, my last point, Mr. Pretorius, is that quite clearly there was executive overreach. There was quite clearly instances of manifestly unlawful or illegal instructions. And that is something that I picked up. I could, with time, go into this. And obviously, oversight was extremely uneven and ineffective.
And this was over a
I'm
long
sorry.
period of time, I presume.
I'm sorry, Mr. Pretorius. You say oversight was?
It was very uneven.
Oversight on the part of
Oversight, to give an example, Chair,
DG giving oversight, Minister giving oversight, Parliament giving oversight. That's what I'm trying to establish.
okay. There's oversight, Chair, by the accounting officer.
Okay.
There is oversight by the Minister,
Yeah.
the Inspector General,
Yeah.
and the legislature.
Yes.
That was extremely uneven.
So when
At
you
all
say
levels.
when you say it was uneven, you say you mean that coming from a certain power source, it might be quite strong, but another source who is supposed to also provide oversight, it might be very weak.
Yes.
Maybe almost non-existent.
Yes.
And so that's what you mean?
Yes.
Okay, all right.
And these issues relating to oversight, executive overreach, I presume took place over a long period of time.
Yes, without
You're not
without
talking
a doubt.
of a particular
Yes.
incident.
Yes. Yes.
You say that on arrival, you would have discovered these matters. Did you call for briefings?
Yes, I called for briefings from various entities within the State Security Agency, and it is in processing and analyzing those reports that, and obviously validating that you determine that, but there's a weakness here, there's a weakness here.
All right.
Why are things done this way and not done that way?
Can you recall what the Chief Financial Officer told you on your arrival?
It was one of the very first briefings I called for because, as I indicated a moment earlier, you follow the money. The distinct one I remember, Mr. Pretorius and Chair, is that, and it arose from this fact, from the fact that most people owed the agency money. It was that when a member, and I suppose this is true throughout the public service, when you travel, you are given a temporary advance. That's for accommodation, food, and. What then happened in our instance was that they would take a funding instrument they would take the temporary advance and use it as a funding instrument for projects. So in essence, what that means is that you come up with a project, you cost it, the project is worth 10 million rand. Through using the temporary advance instrument, they would give you 10 million rand in cash. Now, you implement the project over a period of time, and you settle at the end. And that's why then, once they give Loyiso 10 million, my name would immediately be on the register. Now I owe the organization 10 million. Whereas the proper approach, which has always been there since '95, is that you cost your project. As you build the foundation, you tender an invoice. We give you money for the foundation. You erect the walls. You tender an invoice. You pay for it, and so on, and until the house is fully built up. You don't give Loyiso 10 million to walk out the gate with a sum of 10 million cash, and then you have no control. It's just the wrong way of doing things. That is one.
There may be more evidence of that
yes,
in due course, but
we'll talk to that.
I think, as I understand it, you're saying there was insufficient recording and documentation to justify the release of cash monies within the system. Is that correct?
That's correct, yeah.
But I think you say more than that. You say the correct principles were not followed, were not complied with. The principle in the example that you are giving was you should not be given the whole amount for the whole project at a time. You should be given on stages in accordance with the progress that you are making in your project. And this principle was being breached. Yeah, okay.
I think, Chair, it's what I said right at the beginning, that complying with the law, with the Constitution, was elective. If it is adjudged to be,
If it's inconvenient.
if it's inconvenient to go around it.
Yeah.
It's not that the Constitution is not there. It's not that the Constitution doesn't provide that you can only establish intelligence by legislation.
Yeah.
You just put that clause.
Yeah,
It's like a Word document. You delete that clause.
So it's just that this Constitution and this law is not helping us.
It's a Word document. You can amend as you go along. Yes.
Yeah.
Did you institute or order that any investigations take place after you learnt of the situation on your arrival?
Most definitely I did.
And we'll come to those in a moment. In paragraph 6, you refer to the report of the high-level review panel. That's the panel chaired by Dr. Mufamadi. And you refer to 5 high-level answers to the question that the panel raised. what went wrong. From your own knowledge and experience, you highlight 5 issues or high-level answers that the panel identified. What is your own view of those 5 points that appear at paragraph 6 of your affidavit?
The first point is around the politicization of the State Security Agency. This is fact. There are, and this is how I understand it to have manifested itself, and you see it in the projects that were being run. There are monies that left the agency for the purposes of funding political activity, principally within the African National Congress. And often, when you drill into it, it's not funding the African National Congress credibly. It is to fund activities of a particular faction within the African National Congress. So there would be monies dispersed for that purpose. There would be operations intended to, if you will, to drill into the credibility of those who are not on the faction. That's within the African National Congress. You then have another situation where, particularly whenever we go towards an election, there would be projects that would be intended and funded to enhance the political fortunes of the ANC. And these projects were prosecuted. Now, if you go to, this is a matter of public record, once again, there's AMCU, which at the time appeared to be quite stronger compared to the NUM. And then the State Security Agency is employed to found an alternative union that would weaken AMCU around the Platinum Belt. And then there's so what I'm saying, Chair, is there's politicization that manifests itself on participating in intra-ANC activities. Then now I'm into civil society. And then you have got projects that talk to, and some of these things straddle various themes. They talk to the doctrinal shift, they talk to the point I was talking about earlier, the uneven effectiveness of compliance assurance instruments. Then you've got projects where a media entity is established and the State Security Agency is employed to fund that. Now, nowhere in the mandate of the State Security Agency do you find that the lawgiver anticipated that this entity would also fund a media entity within South Africa. Towards what end? It must be a political objective. Then there is, I'm sure Dr. Mufamadi spoke to this, there is a Project Justice, intended in part to influence the judiciary. I put it in this category on purpose because by the time you have a project intended to influence the judiciary, it presupposes that there's other work that has been done, and the determination has since then been made that to cure whatever ill there is with the judiciary, you need to influence the judiciary. I don't know if I'm putting this thing across well. So it's quite okay to be quite shocked at the fact that there is project justice intended to influence the judiciary by an intelligence agency. But then the question is, what happened to arrive at this solution that is being implemented in this fashion? So you have to assume that the judiciary was a target for intelligence operations. Now, that can only be political. The Constitution provides measures, processes, institutions to deal with any concerns around the judiciary, be it court rulings or misbehavior of whatever nature by those in the bench. It is nowhere anticipated in our constitutional construct that intelligence would be employed to influence the judiciary. If anything, intelligence should alert the judiciary to say, Deputy Chief Justice Zondo, your distant cousin or the friend to your son is in fact a member of a syndicate. You ought to be careful about this. That conversation with the ambassador of Amazon is not a good intentioned person, that sort of a thing. But to influence the judiciary in the manner in which this was done. This is how this politicization manifests itself. The doctrinal shift, as I said, Chair, these examples straddle these themes. National security, as outlined, at least in the values and the principles in the Constitution, doesn't sit comfortable with a definition of the entity as a state security. The emphasis is on safeguarding and advancing the interests of the nation and not necessarily of the state. Theoretically, the state exists for the nation, but the emphasis must not be on the state, it must be on national interest. And you do that well if you locate it in absolute respect and adherence to the letter and the spirit of the Constitution. And so for me, several of the wrongs that we have witnessed derive from moving from national security to state security. Now, once you say state security, by definition, you are gravitating close to the person of the head of state. And that is always the risk. So if there is politicization and there's this shift, inevitably, and maybe even inadvertently, you could easily end up with regime security instead of national security. So you exist to protect the fortunes of the regime and not national security. So it's a construct that might appear as an academic construct or level of abstraction, but these are important principles. The third point raised in that paragraph, Chair, is around the amalgamation. The the situation that obtained after 95 disaggregated responsibility and authority stroke power over the conduct of intelligence. Domestic intelligence, national intelligence agency with a domestic mandate. South African Secret Service with an external mandate. Then there's signals intelligence, which is focused outside the country. Then there's Office for Interception Centers, which is doing interceptions on the basis of a judge authorization. What happens with 2009 is that all of that authority, which had hitherto been dispersed, is now concentrated in one pair of hands. The best democracies in the world, viewed from the point of view of the letter and the spirit of our Constitution, don't have that construct of having all of this authority located in one pair of hands because of the inherent risk, and I suppose this is something that we'll talk to Mr. Pretorius, secrecy. To work in secret as is absolutely necessary for intelligence. If you have bad people in one or two or three places with this kind of a construct, abuses become easy to do. And the risk here is that, Chair, this is real authority. This is not abstract. This is not theoretical. This is real authority. You can, or I can, destabilize South Africa and destabilize other countries in the region by virtue of the fact that I have the authority over all intelligence operations of the state security agency within and without the Republic. And that makes it difficult for effective oversight. Secrecy, we can't do without secrecy. It is absolutely necessary. The problem is not the secrecy, not at all. The problem is when there is no effective oversight over elements of that secrecy. Then secrecy is not transparent in the eyes of those responsible for oversight. And because there's no transparency, accountability is going to be subtracted from quite considerably. So secrecy requires a very measured degree of transparency and very robust accountability. When those two are not rigorous enough, secrecy becomes a problem. But of itself, it is not a problem. The last point, Mr. Pretorius, is resource abuse. My experience tells me that on the surface, this talks about money. Yes, to be sure, I believe money was stolen. People enriched themselves. Very fictitious projects could have been implemented. And we've got evidence to prove that. But there's other resources that were abused. And this talks to assets, firearms. These are resources of the state security agents of the state. The state gives us these firearms in order for us to discharge our responsibilities. From a defensive point of view, I must clarify. And because our members, if they operate in a very rude environment, they've got to be able to protect themselves. But when you have a situation where firearms of the state are then given out to non-SSA members, in a manner that is completely outside the relevant prescripts. That constitutes resource abuse. When you've got personnel of the agency being deployed to carry out responsibilities that fall outside the mandate of the state security agency, that's an abuse of those resources, of such personnel. When you've got fixed assets or immovable assets that get registered in the name of Advocate Nsebeza, and they become part of his estate, that's resource abuse. And we've got those. I'm by no means suggesting that he's sitting with an asset base that was funded by the SSA.
You thought you should clarify that lest you may be sued.
Yes. Yes. But over and above that, Chair, those 5 bullet points, I would plead that they be understood together with the input I made about, which is systemic, these compliance assurance instruments, the specter of illegal instructions, executive overreach. All of those they've got to be added together with these 5 bullet points on paragraph 6.
We will deal with those. Perhaps this is a convenient time to take the long adjournment.
Yes, we'll take the lunch adjournment now. It's 1:05. Ordinarily, we would resume at 2:05, but I'm just going to add a little bit more time to enable me to attend to something. So let's resume at 2:20.
Thank you, Chair.
We adjourn.